In England and Wales, there are two ways in which parties can jointly own property. One is called joint tenants, and the other is tenants in common. With joint tenants, you both own the whole of the property together, and therefore if something were to happen to one of you, the other party inherits the whole of the property automatically by survivorship. Think of it like two hands holding a handbag, and if one of them drops away, the other is left holding the whole amount. With tenants in common, you have two parties who own their own individual shares within a property. These can be specified by percentages, or could be done on a basis of calculation depending on contributions. Each party has their own share that they can deal with and leave via a will or sell as appropriate. A trust of land sets out how parties own a property and how their respective shares are worked out. This can be an express trust where parties have set out in writing exactly what their percentages are, but there are also ways that trusts can come about, such as resulting trusts, where a party provides money towards a property that ends up in defining what share they own, or a constructive trust. If you have never specified what the exact percentages in the property are, then there are a few stages you would go through to work this out. First of all is whether you can come to an agreement with the other party, and it may be that you have your own method of making a decision on that basis. But if you can't agree, then the court might look at your behaviour, what could be assumed based on how you have dealt with the property as to your respective percentages, such as what payments you have made towards the mortgage. And finally, if that can't be deduced, then the court might look at what is fair in all the circumstances based on the history of the property ownership. If you jointly own a property with another party and they're not coming to an agreement with you as to how to deal with it, there are a few stages that you would want to go through. First would be attempting to resolve the matter in an amicable way, such as mediation, or if that's not going to work, then perhaps looking at solicitors' negotiation to see what can be done. There must be an easy and cheap way that we can resolve this dispute. If that's not going to work, ultimately you may need to look at referring the matter to court. But before then, you would be doing something called a letter before action, which sets out to the other person exactly what the nature of the dispute is, the points you've been able to agree and disagree, exactly what it is that you're claiming from them, and what remedies you're seeking from them. If that doesn't elicit a suitable response, then you might need to issue court application for the property to be sold accordingly. There are a few factors that the court is going to have to decide when resolving these kinds of disputes. The first is working out what exactly your percentage ownerships in the property are, and the judge might be looking at things like, was there an express agreement written anywhere, or was there one between the parties that they can both rely upon? If not, we might need to look at what sort of behaviour the parties have been going through in respect of the property to determine what their respective shares are. Once we've worked out the shares, the court then has to decide whether it's appropriate for the property to be sold. If one party has a lot of capital tied up and they need it for an onward purchase or simply to be released from a mortgage, then the court might need to investigate whether a sale is the only option or whether one party has the ability to buy the other out and, importantly, release them from the mortgage. The court have a number of decisions that they can make in these types of cases. First is that they can decide what respective shares of the property each party owns, defining their percentages so that the other decisions become easier. The second is that they can look to order a sale of the property if it is appropriate. If one party has all of their capital tied up or needs releasing from the mortgage, a sale may be inevitable. If another party wishes to buy the other out, the court could order a window of time to allow this to happen, but is likely to look at a fallback sale, as we don't want to indefinitely have promises of buying the other party out if it's not going to work. Finally, this is a matter for civil law, and therefore there can be costs awarded for a party who has brought a claim and is successful in achieving the same. This is a different position from other areas of family where costs are unlikely to be awarded, and therefore it's very important to get legal advice on this so you know exactly where you stand.